Thanks for having me. What it basically comes down to is there wasn't confusion amongst jurors. There just seemed to be confusion amongst the public. Somehow, for whatever reason, they thought that customary marriages are subservient to civil marriages, in that if you do a civil marriage after customary marriage, that somehow what you do in that civil marriage then either nullifies or replaces or overrides whatever happened in terms of your customary union marriage. And what the court has just basically confirmed that if you're legally married, whether in terms of the Recognition of Customary Marriages Act or in terms of civil union or any of the other acts, they all have the same status and the same rules that apply. And what that basically means is in our country, if you do not have an antenuptial contract or a prenup, the default position is in community of property. Whether you're married in terms of customary law or in terms of civil law, if you want your matrimonial property regime to be something else than in community of property, like you want it to be out of community of property or out with accrual or whatever the case may be, the bottom line is that you have to register an antenuptial contract. And you cannot simply say, well, I didn't register an antenuptial contract when I got married in terms of customary law, but now I'm getting married in terms of civil law. I'm going to make it out of community of property, registered antenuptial contract, and now simply, somehow, for some mystery reason, your civil marriage outranks your customary union, and therefore, now by a stroke of the pen, you're now married out of community of property. And the court said it doesn't work that way. They both have equal status. And if you want to be married in anything else than in community of property, or you want to register an antenuptial contract post your marriage, there are the same steps for everyone that you have to go through.
Shando, I'm laughing because I'm just in disbelief. Look, there's one thing about the law is it's never confused. Okay, there's a lot of things that's going on in the legal space when it comes to marriages, whether they are customary or the Western way of doing things. But one thing the law is, it is not confused. Okay, and there's a lot of things that you bring up in your response that I didn't even think about. When it comes to equalizing the scale between a customary marriage and a formal marriage, as it were. But let's talk about what needs to happen. Okay, because I don't think we do our homework when we're in love. Something happens, I don't know if it's chemically or whatever the case is, we just do not do our due diligence correctly before we get into customary marriage, and we don't understand the legalities and the repercussions should things become, for the foreseeable future, as it were. So what do I need to do? Me and Sipho have decided we want to get married in a customary way. Do we have to have paperwork ready before Sipho sends the uncles to my gate, or what needs to happen?
Well, various things need to happen, but see what you've done as well. You've not said, oh, people make the mistakes. They don't do their due diligence when they get married in terms of customary law. People don't do their due diligence when they get married. Doesn't matter in terms of what. Whether it's civil law or customary law, love is blind. And people think very few people, unless it's an 18-year-old marrying a 96-year-old billionaire, most other people don't get married to get divorced. You don't think, oh, it's not going to happen to me. Even though 3 out of 5 marriages ends within the first 7 years, you somehow believe you're not going to be part of that stat. You're falling outside the bell curve. You're special. You're different. Your relationship is different. You know what? Your relationship goes through the same ups and downs as everybody else's relationship. So what people need to do before they get married, and there's certain rules in terms of customary law which you don't have in terms of civil union, like a lobola note. A lobola note is like a wedding ring. It's where you show that you intend to get married. And you have to do a couple of other things, the formal handover of the bride, etc., etc. But it makes logical sense. And the people have to be above 18 years old, and they both have to consent to the marriage. Well, that applies to normal civil marriages as well. You can't force someone into a marriage; they can't be underaged, etc., etc. So those are normal rules in terms of natural justice. They're not rocket science. So, but if you want to get married in terms of if anything else outside then the marriage regime of in community of property, you need to register an antenuptial contract before. Well, you need to sign it before you get married, and conclude it before you get married. State what you want your matrimonial property regime to be, in case in case the marriage or the relationship sours. Remember, one day your marriage will end. It will either end by death or by divorce, but your marriage will end. So if it ends by death, you need a will. If it ends by divorce, you need an antenuptial contract.
Yeah.
So it's basically a document that does very, very similar things. So it just depending on the circumstances. So the bottom line is, and what the law does is, what it's supposed to do is create certainty. Let me explain to you and what the law said here is, there's a couple of maxims that forms part of most Western legal systems. For instance, innocent until proven guilty. He who alleges must prove. And two other ones that apply in this instance. The one is that it's called prior intempore, prior in jure, which means first in time, first in right. If you got married validly in terms of a customary union, you can't now, after the fact, do a second marriage, which sort of pretends that the first marriage didn't happen. Because it's first in time, first in right. If your marriage was first and valid, then those rules apply right through. The second maxim, or another maxim that applies here, which applies to most Western legal systems, if your rights are affected either by a change of status of the person, let's say they become insolvent or bankrupt or divorced, or they change the antenuptial contract. If your rights is changed by a status of a person, is affected by the change of a status of a person, or is affected by a judgment, then you need to be notified. You can't just find out about it after the fact. And if you change your antenuptial contract after you got married, and there's a process for it, it needs judicial approval, the court has to see that the peoples whose rights are affected, who are they? Anybody that gives you credit, the bank for a bond, finance for a car, credit card, overdrafts, all those things, their rights are affected by your change of status. Because previously, they could sue two people if you're married in community of property, you and your wife, you and your partner. Now you change to out of community of property, and their whole risk increases because they can only now come after one person and one person's estate. Now, can you imagine, based on you being married in community of property, you get a certain risk profile, and your interest rate gets determined by that, your amount of credit gets determined by that, and now suddenly, arbitrarily, without informing the banks or the credit providers, you can change that. It would have excluded, your risk factor would have gone, if you've been married in terms of customary law, just that mere fact would have put your risk factor off the charts and would probably exclude you economically from getting a bond, from getting credit, because you could now go behind those people's back and just arbitrarily change your marriage system. It would exclude a huge portion of our economy. It would make it impossible for them to get credit or bonds. So I'm glad the court has now put certainty on it that said, if you're going to change your matrimonial property regime post getting married, you must inform the people who will be affected by this, which is your creditors, and they must have a chance to object, or at least you must show that you notified them and that they're fine with it.
Shando, this is a masterclass of note. It's 23 minutes after 1 p.m. Central African time. We're going to take a quick breather. When we get back, we continue our conversation about the Constitutional Court of South Africa's ruling, clarifying how property rights work when couples move from a customary marriage to a civil marriage. Don't go anywhere.
Let's just do it.
Your life just got easier. Get the Channel Africa app and take us wherever you go. Catch the latest news, enjoy your favorite shows, stream the music you love, and stay connected to the continent. All in one spot, right in your pocket. Simple, quick, and always with you. The Channel Africa app. Download it now on iOS and Android. The Upside. On the Upside, your voice matters.
We continue our conversation with Shando Theron, specialist divorce lawyer at Theron Inc, Johannesburg, as he unpacks how this Constitutional Court ruling, clarifying how property rights work when couples move from a customary marriage to a civil marriage. Shando, let's talk about the couples that have now, let's say, divorced. I'm using an extreme example now. They initially got married under customary marriage, And then later on, they decided, okay, cool, we're going to enter into a civil marriage, and we're going to have prenups involved, prenuptial agreements, and they signed them. And then along the way, they got divorced. And then it got complicated there, where now the assets are not split correctly or whatever the case may be. What is their recourse now? Are they able to go back and say, but no, we were initially married under customary law. That means that in community or property, and therefore whatever prenup we got into after that is invalid. What steps do they now need to take, as well as those couples now who are trying to do the same thing, which is move into a civil marriage after having done so customarily?
Well, as you put out right there, that's a head scratch that I have often in my job. People come to me and say, oh, well, we married in terms of customary union in 2009. And I'm obviously using the facts of the current matter. And in 2021, we registered, and we got civilly married and registered anti-nuptial contract. And now in 2022, the relationship soured and we're getting divorced.
Yeah.
And now one party says, no, but we married out of community of property, therefore you can only get that. And the other party says, no, we were married in community of property in terms of customary law, and therefore we are, the anti-nuptial contract that we registered post our initial marriage is invalid.
Okay.
So basically what the court, this is the facts of the current case, and we deal with this often.
Yeah.
So basically, what remedy do they have? Firstly, in the first instance, if they now get divorced and that anti-nuptial contract was not registered, it was not approved with judicial oversight, in that the people who were affected by this change of status were not notified. And like I said, one of the maxims in our law is if you get affected by something, you need to have a chance to actually say, but I object. So because they were not given that, and because this judgment has now placed, it's made it absolutely unequivocal that customary union and civil marriages, the one does not outrank the other.
Yeah.
It's whichever one you concluded first. That's the one that counts, and they are on equal footing. So if you want to then register an anti-nuptial, now for the second group of people who say now, but okay, we still want to register an anti-nuptial contract post our marriage to change our marriage regime, the same rules apply for both. Draw it up, do an application to court, show that you've given notice to your creditors who will be affected by this, so that those creditors can have a chance to object. And if they choose, if you can prove them that they've been given notice and that they do not object, the court will then approve it. So the court has basically made it unequivocally clear that both forms of marriage, if legally concluded, are of the same status. And should you wish to get divorced, the same rules basically apply to both when it comes to divorce. There's no difference. The one does not outrank the other.
Okay. Okay, so for people that are already in a difficult position, if we could put it that way, you've gotten yourself into a customary nuptial, and you've decided you want to get out. You've obviously now got to involve the law. So what do I do? Do I obtain a divorce decree? And also, how does this law now that it's been stipulated legally and it's publicly out there, how does that sort of protect women's property rights in this case?
Okay, well, there's another judgment that isn't part of this that came in September last year, that says, let's say for some instance, let's say you registered an anti-nuptial contract, it was legally registered, whether you got married in terms of customary law or civil law. It says that, and now this is in line with I think with what's happening in most other legal systems as well, Western legal systems, is that before a anti-nuptial contract was treated purely as a contract. And one of the maxims, when I'm talking about legal maxims that apply with contracts, it's caveat subscriptum. Signatory beware. If you signed that contract and you were sober at the time and you were an adult, don't cry about it later. So the law used to treat anti-nuptial contracts like a normal contract. If you signed it and you were an adult, then you've got to deal with the consequences. Too bad, so sad. Very gladly, we're very happy about this. Last year in September, there was a judgment that said, even if you have an anti-nuptial contract, and I think it can be read into it that even if you're married in community of property, the law can, at its discretion, and in terms of the rules of fairness and justice, still ask that still has a discretion to redistribute assets to protect the vulnerable parties, generally the economically not stronger party and the children or the aged and the infirmed. So the court has taken it upon itself to stop really unjust judgments and unfair judgments and say, but listen, we have a discretion in terms of the Constitution. Section 28.2 or 28.2, I should know this, says the rights of children are above all else. So you can't give a judgment that puts children out in the street. You can't give a judgment that also discriminates against a woman based on the fact that she has put her life on hold to raise children or to work in the business, her own career on hold, to support you, and now because you're married, clean out of community property, you can now kick her out on the street with nothing. So the court has taken, so that's when you had an anti-nuptial contract and your position is clean out of community of property. But when you're married in community of property, and half of everything, half of nothing is still nothing, but that's the old joke in law. But the court can, and you can ask for a forfeiture of assets. We have a no-guilt divorce system, but it's not completely no guilt. If you, let's say the one party has suffered long-term abuse, financial abuse, physical abuse, economic abuse, lots of other things, and that has led to, in a sense, the relationship uncoupling and souring. There's also another maxim in law that bad behavior should not be financially rewarded. So that person, the court can show its displeasure by redistributing assets that is alone in that person's control and say, but listen here, for sake of fairness and natural justice, she should get the house or half the pension fund or half that. So you're never, as things stand now, no matter how you're married, you're never completely without remedy.
Shando, we're going to send people in your direction so you can scratch your head a bit more. I'll ask them to check out Theron Inc Incorporated, Johannesburg, the voice of Shando Theron. He's a specialist divorce lawyer. If you have any questions for him, need more clarity, please reach out to him. It's 32 minutes after 1 p.m. Central African time. Let's get the latest sports.
Sport.